Okay, so if a session with one lawyer wasn't good enough, you're now going to get a session with 2 lawyers. Everybody is so excited, right? Okay. So other than my day job, one of the things that I've done for the last 20 years is I teach as an adjunct professor at Webster University. And so every semester I get a new group of students, and when they find out that I'm a lawyer, the first thing they do is they want to tell me their favorite lawyer joke. The good news is we actually have my favorite lawyer joke, which actually leads into what we're going to talk about today, and that is doctor, lawyer, and engineer standing around talking about what is the world's oldest profession. And the doctor says, well, if you look in the book of Genesis, of course, God made woman by removing a rib from Adam, and that's a medical procedure, and therefore medicine is clearly the oldest profession. The engineer said, well, that's fine and dandy, but if you look a little earlier in Genesis, you'll see that God created order out of chaos. That is clearly an engineering function. So engineering is the oldest profession, and the lawyer smiles and says, where do you think the chaos came from? And so when we talk about this idea of legal and compliance being supportive of an effective drug testing program, we start with in the beginning. And in the beginning,
there was risk. And risk, I have to have a little note here, is the possibility of the adverse consequence, whatever it is. Out of that comes legal. So legal is the method by which we deal with the adverse consequence. And out of that,
and about 15 years ago, companies decided that maybe it was less expensive to try to prevent problems than simply fix them after something broke. And that's where we came to the idea of compliance. And compliance is really about how do we avoid the risk? How do we keep the risk from being a part of what it is we have to deal with? And not that I don't enjoy calling Faye on a regular basis, but how can we stay out of those things like lawsuits and other things that cost us money and actually are a tremendous distraction to the work that we do in our organizations?
So let's talk about what legal is first. What it does for you. I know you guys are struggling with this one, but why lawyers are good, but go with me on this. So the first off, it identifies the legal minimum standards. What is the bottom line of what you've got to do for whatever regulator to avoid lawsuits, whatever that is? Lawyers identify risk points. What are the risks in your process to meet these minimum standards? Lawyers typically partner with compliance for execution. I can tell you I certainly do with my clients is, again, keeping them out of lawsuits is my #1 goal. And then my secondary goal is to stand in the gap when bad things happen. That's where the lawyers are outward facing now and saying, all right, we did everything we could, but humans are involved in this process. So the bad thing, whatever that is, happens. They stand for everyone.
Anybody know who that is? That's Elizabeth Holmes. I'm going to tell you a little story. And the story is about how if you just spend a little time with compliance, you can sometimes avoid a whole lot of legal issues. So Elizabeth Holmes is the founder, or was the founder, of a company called Theranos. And Theranos was and notice I speak of Theranos now in the past tense. Theranos was a diagnostic company that was developing a technology in the laboratory space where you could do testing. And if you'll notice in the middle picture at the bottom, it looks like she's giving you the OK sign. Well, she's not giving you the OK sign. Between her thumb and her forefinger is a little device called a nanotainer. And the nanotainer holds a little bitty sample of blood, and it can be procured from a finger prick. And in 2003, she was a 19-year-old sophomore at Stanford University. And the reason I bring up the fact she was a 19-year-old sophomore at Stanford is because any article you ever read about Theranos will tell you that she was the 19-year-old dropout from Stanford University. Okay, so that's why I bring that up. And she went to her professor, and she had this idea for this disruptive technology. And her professor, which I find very interesting, encouraged her to drop out of Stanford and pursue her dream, and so she began to do that. And over 11 years, from 2003 to 2014, she amassed $450 million of venture capital to start her company. And in 2014, this company, which had never generated substantial revenue at all, was valued at $9 billion. To give you some context there, the two largest labs in the United States, Quest Diagnostics and LabCorp, each have valuations in the neighborhood of $8 billion. They actually do generate revenue. Theranos had not. And Elizabeth Holmes was touted as something of a Silicon Valley unicorn and had personal wealth that was estimated in Forbes of $4.5 billion because she owned 50% of Theranos. In 2016, the Centers for Medicare and Medicaid Services, CMS, sent Theranos a letter that said, you are placing your patients, because of the regulatory and quality failures that you are having at your laboratories, you are placing your patients in immediate jeopardy. That's what the IJ stands for. It was an immediate jeopardy letter, and shortly thereafter, in March, they issued a 121-page report that said all of the quality and regulatory problems that Theranos was having. In June, CMS says, hey, you haven't fixed anything. We're going to give you 30 more days, and then we're going to pull your license. 30 days later, in July of 2016, CMS pulled Theranos' laboratory license. And you think, gosh, isn't that a terrible story? Well, it gets worse, because 3 weeks after having their laboratory license pulled by CMS, for the first time Theranos said, hey, maybe we ought to go hire executives that can help us with regulatory and compliance and quality. Now think about that. This is 2.5 years after the company has reached its initial funding stature. They've got the federal government saying to them, we're going to take your license away, and it's not till 3 weeks afterward that they decide that maybe we ought to get somebody in here that can do compliance, quality, and regulatory. In 2018, Ms. Holmes is currently under indictment by the Department of Justice. And last month, Theranos actually dissolved and went away. And so here's a person that when she was a little girl was afraid of needles. And because of that life story and her personal desire to make things better, went down a path and ultimately ended up with being indicted and facing likely jail time. So, as a contrast to what legal does, compliance is about policy. What is it we do? You heard Faye talk in the last session about making decisions about what it is your policy is going to be. Policy is tied to that minimum standard that Faye talked about, but it is also about how do we set policy so that we can administer effectively in what it is we do as an organization. Not only what is it we're going to do, but then process. How are we going to execute that? I'm going to guess a lot of you have a lot of challenges because you've got a lot of people in a lot of different places. And trying to administer your programs across those multiple states, multiple industries, multiple verticals can be very difficult. And once we set policy and once we set process, then how do we train folks so that they know what we're going to do and how we're going to do it? And then compliance comes in from an auditing perspective and says, are we in fact doing what we say we're going to do? And then we innovate. After we assess and we see the gaps and we see how things may or may not be working, we say, how can we do it better? Think about if Elizabeth Holmes would have had those kinds of activities going on in her company when, in fact, the technology that she was touting and capturing money for actually didn't exist. What if she would have been in a position where someone could have sat down with her and said, Elizabeth, you've got a great idea. It's not ready for prime time. Quit saying it is.
Okay, so let's talk about what compliance means to customers, to you and the people that you report to. David, why don't you explain?
So customers expect compliance every time. Every time. And they expect it in every situation. So the idea that we can be almost always compliant means you're not compliant. Okay? And despite every effort that you will make in a compliance program in your company, the bad thing will happen. It's going to happen. I mean, don't think for a minute that you can create a compliance program that is broad enough, effective enough, strong enough, with enough resources and enough money that you can keep the bad thing from happening. Because here's the deal. The bad thing is going to happen. I used to say back when I practiced that a lawsuit is nothing more than a filing fee and an 8.5 by 11 sheet of paper. Anybody can file a claim. So the bad thing is going to happen. The most important thing is, from a compliance perspective, you've got the how do I keep it from happening, and then what do I do after it does? Because most of the customers, in fact all of the customers that we work with, understand that bad things are going to happen, and then they look to us to say, how are you going to react when that bad thing happens? And so, from a compliance perspective, when we are faced with the bad thing, the first thing I ask is, am I going to call legal? And you saw in Faye's last presentation, we talked about this idea of getting legal involved. Well, here's why you get legal involved. You get legal involved because there's this idea of the attorney-client privilege. How do you protect and maintain information in a way that you can protect yourself from disclosure of information that you otherwise may not want to disclose outside of your company? As a compliance officer, I am all about prompt and effective investigation. I want to know what happened, how it happened, why it happened, what's the root cause, because I'm the one that's going to have to make internal recommendations to executives to say, this is how we need to move forward. So I'm going to want to know immediately, how do I know what happened and how are we going to fix it? And then the third bullet here is really about compliance is like trying to explain quality. It's trying to explain information security. When you say the word, everybody goes, oh yeah, I get what that means. But then when you try to describe it, you all of a sudden find yourself down a rabbit hole that you don't want to be down. Okay? Here's what I know clients want to see from us from a compliance perspective. They want to see a program. They want to see things that you do every day, all the time, in a consistent, programmatic, systematic basis, so that then they go, okay, I get it. I get it that you guys get it. And that's what your clients have to walk out, that's your customers have to walk out the door with from a compliance perspective when the bad thing happens, and as they continue to assess every day, are you doing the things that I need you to do?
So let's talk about this now in this space, the drug testing space. And so one of your questions is, how many people here are involved in safety, DERs, okay, that's everybody. So who are your clients? Who are your customers? Because you might say, no, I'm the customer. And actually, for a compliance world, that's not really right. You certainly, your job as a safety is to provide to your company a safe workforce, to provide as much safety as you can. They're your customers. You have to make sure to provide good personnel in the case of drug testing. Who else is your customer? The donor. You owe it to them to have an effective, fair, and compliant drug testing program. And by the way, both sides will be happy to tell you when you don't get it right. But so what we've done here, and we're going to walk through it, largely on marijuana, but we're going to use some other examples to talk about the various players in this space. What things, challenges they faced, how you as an employer or someone monitoring them, what steps you might take to make sure they do the right thing and handle bad things. So we're going to look at the collector, the lab, the TPA, the MRO, and the employer, kind of work through a time chain here to give examples to show in a practical world what David's talking about. The idea that Compliance sounds nice, and by the way, usually you don't like it when they show up because they come and audit you. But they also could be your partners and make things much easier and much more effective. And so we'll try to do this, use some examples, real life. I will guarantee you that there is no example we're going to talk about that has not been, for me, through my decades of work in this, has not been a real life experience. But it often centers around, for drug testing, around the donor. And other people perform pieces of that event. Okay, so let's talk about the collector. Some of you, I mean, you know, DISA controls some of the collectors. They do a great job. But we're going to talk about when things are not going so well. Okay? So I'm going to use my favorite state of Maine because it gives you a headache every time you think about it. There are very big state requirements in Maine, some of which are extraordinarily difficult for you as an employer to manage. We're going to go through some of those. They have to have alternative matrices. I'm talking about things other than urine collected a certain way. But let's talk about marijuana. Let me tell you the rule in marijuana in Maine, and then you can just sort of shake your head. Any donor who, first off, there's cutoff levels that are mandated. So you have to make sure that you have panels to do that, and we'll talk about that in a minute. But more importantly, a donor shows up at a collection site in Maine, and he says, or she says, oh, no, I don't want my urine tested for marijuana. I would like you to draw a blood sample. Okay? And everyone else is going, say what? Okay? And furthermore, I want you to test it at a specific level. Say what? We don't do blood. And furthermore, I want you to not test my urine, which you're going to test for the other drugs, for marijuana. I want you to have a different panel that doesn't have marijuana on it, and you have to tell the lab that that's not going to be tested. Oh my. Yeah, folks, that's the law in Maine. All of what I told you is absolutely true, and by the way, they can get attorney's fees from you if you do it wrong, from the employer. Just so you're clear about that, it is really, really ugly. That is the law. So first we're going to talk about compliance, let David talk about compliance, and then I'm going to come back to some legal strategies from a drug testing space to talk about that. So given that framework, David, can you help us out with some compliance?
So you're going to hear me say this as we go through each of the examples, and the first is build a consistent documented process. And I can, even though you all are being very kind that you're not going to roll your eyes in front of me, I know that in your brain you're rolling your eyes saying there's another lawyer telling me to write policies and procedures. Here's the deal. If you don't write policies and procedures, how do your people know what to do? Okay? Do you want to know your number one worst compliance asset? Is your employee's memory. Oh yeah, I know how to do that. I know what I need to do. I know what I need to do in Maine when that donor says, I want this, that, and the other. And you may have people that do know. There may be collectors that do know. But I will tell you that for every collector that does know, there is a collector that doesn't know. Or there's a collector that thinks they know. And so documented processes are not the recovering lawyer in me that is saying, oh, just got to have more paper. More paper is what matters. No, it is not what more paper matters. It is about having, when I talk about having a consistent documented process, what I mean is having a process that you can put right under your employee's nose so that they understand what they need to do. Not in the happy path. We talk a lot about the happy path. Okay? The happy path is when everything goes as it should. Part of what I think compliance's job is to understand in each process, where do we diverge from the happy path? Where do things go sideways that somebody better know the precise thing that they need to do, or you've just gone from the happy path to the sad path to the, oh my gosh, that is awful path. And a lot of times you can fix it. And so I talk a lot about, with our folks, creating guideposts. So when X happens, Y needs to be done. So for instance, there are 10 steps in a federal collection. This will sound probably crazy to most of you, but I would be a big proponent of taking the 10 steps of a federal collection, putting it on a sheet of paper, laminating it, and putting it on the wall where your collectors are going to collect. And you think, well, that's the dumbest thing I've ever heard. Don't my people need to know what that is? I get it. But I know you've got people that have been probably in a collection agency collection site for 10 years, and some have been there 3 months. That little laminated piece of paper is a huge way to make sure that we're not relying on their memory. We need to then train to the process. And let me just tell you, the number one awful thing that you all have to do and that we have to is training. It's awful, okay? And it's awful because we don't want to do it. And it's awful because we don't get creative about it. If you want people to learn something, you have to make it so that they want to learn it. And you can do that either by the stick or the carrot. And the part of the carrot is making it so that they understand the value of doing it right and staying on the happy path. And then lastly, you audit to the process. Faye just mentioned it. Lots of people don't like it when compliance shows up because we're going to audit somebody. Well, guess what? Part of auditing, if you do it right, if you have the right kind of framework in a compliance program, you ought to be coming in a collaborative way to assess the process so that your customers, in my case, I think of them as my operational colleagues. I'm not coming in to ding them. I'm coming in to say, hey, did you know that you got a gap here? And let's talk about how we can close that gap so that you don't have to worry about that particular thing happening.
Okay, so I'm going to step in and talk now about using David's format. What do we do about the crazy Maine collections for marijuana? So the biggest thing you have to have is recognize in advance what you're going to need. You're the DER. You're the only one who's going to know whether there's going to be a Maine resident going there to the collection site. You will have had to have in advance the correct test panel, because when the lab gets it, they don't know whether the person said yes to urine, no to blood, or whatever. You're going to have the test panels for blood and urine at the proper levels. You're going to have a provision and a test panel, a urine test panel that doesn't have marijuana on it, set up in advance. This is David's documented process. And you're going to have to then sort of have the procedure work through. This is all in advance. You have to recognize the law and recognize the requirement, which is just, again, it gives you headaches. One of the ways we can document and create guideposts is, and you've heard me talk about them, one of the biggest ones in today's world for collection is ECCF. Any of you, who've ever had the opportunity to walk through it, it's quite fascinating. I think in another life I could be a collector if I needed to. And I could, but you walk through it, it doesn't let you proceed. It provides the guideposts for you as you go along. And as a collector, you have to do X before you can close it and move to the next step. So that's one of the things in Maine. If the person comes up, if they say, no, I don't want it tested, you've got to know that. You need to train to it, and then you audit. So in a collection site, it's often you have what I'm going to call, I'm old enough to remember secret shoppers. That's where someone would go into a department store and pretend to buy something to see what the customer service was like. In the same way with urine collections or hair collection or oral fluid collections, you can go in and have a process of auditing your collection sites, where you end up going in what I'm going to call having fake collections, but see if they do everything right. And I'm not talking the happy collections, I'm talking the difficult ones. So those are all methods where you can use these compliance in advance, because then if the bad thing happens, the other thing I notice is your customers, your operation people, your executives, they're a lot more tolerant if you had a process in place and that you had a human error. I think we all know that. But that's sort of an example with a very, very difficult Maine collection. And it's equally true if you're in Iowa and you always have to do a split. You better have a process that knows to it. So that's sort of our example on collector. So let's use the lab. It works out so well, I'm sticking with Maine. Okay, so there are state law issues in Maine. There are licensure requirements. There are specific Maine laboratory requirements, and there's fluoride THC cutoff issues. So that's our scenario for you as a DER, as an employer, is saying, is my lab doing the right thing? This is the issue for the lab. on this particular one. David, what do we got for compliance?
So, again, what are the licensure requirements, process for implementing those requirements, and then a system to check to ensure. Again, my world is pretty consistent. The only thing that really changes is the substance. Figure out what you're going to do, figure out how you're going to do it, implement it, audit it. Here's what I would share with you about this idea of compliance, and that is, many of you may remember, it was probably 25 years ago, Hewlett-Packard had a national ad campaign, and what was their question? Anybody?
Help us out, David.
What if? Right? That's what compliance is all about. Compliance is about looking at what you do and saying, what if this happens? What if that happens? And then building behind the what if question the answers, the infrastructure, so that when your operational colleagues, when the folks that you are partnering with as a compliance program run across that what if, here comes the infrastructure. Boom, there it is. We need to have the ability to get a blood draw. We need to have the ability to have a test panel that has only certain things in it. And when these things are triggered, when this what if happens, there it is. I would tell you that is what I spend most of my time as a compliance officer doing, is asking those questions of, if we're going to do this, what if we do this and this happens, what do we need to be in a position from an operational perspective to be able to execute on? And then working with my operational colleagues to say, how can we do that? And I'll help you, because here's the requirement. Now let's figure out how we get that done, because the last thing you want is that when that what if happens, your person at the front line is saying, I don't know what to do. Because then you've got probably 100 things that can happen, and very few of them are good.
So let's talk about a few things, and I'm going to stick with my main example in a laboratory. So you're now the employer, and you're looking, and you have employees or applicants in Maine. What are you going to do? Well, first off, either you, or you could delegate some of this, but it has to get done, is you're selecting a lab. Is the lab licensed in the spot it needs to be? In this case, they need to have a Maine licensure. Do they have one? I mean, I know that's sort of a check the box, but it's kind of a big check the box, if you follow me. Secondly, you're going to have to, in a case, now that we've covered the collectors in the lab, you're going to have test panels developed to adequately cover, to test at the right levels for your Maine residents. Make sure the marijuana. You're going to have to make sure to implement the requirement that you have a test panel that doesn't include marijuana, because it's the ahead of time process. It's very, very difficult. I guarantee you, if you don't have ahead of time the proper panel set up, it won't happen, because it's going to be collected, sent to the lab, and get reported, and then you go, oh my God, that's not going to happen. And then you're going to have to go back and double check against it, which is sort of the auditing process of, do we have this in place? Do we need to tighten it up? Because these are the requirements. That's what they're entitled to when they do non-regulated testing in Maine. So it's the follow-up on it. My favorite, the MRO. I have a lot of MRO clients, and they always have a real tough time with what to do with medical marijuana. Kind of feeds a little bit about what I talked about earlier, but let's do it. So here's the situation. Non-regulated testing, and the donor claims medical marijuana card holder status. That's the situation. What do we got, David?
So again, this is going to carry on with what Faye talked about earlier. You got to have a decision tree. Again, if you're dealing with a large MRO, you're going to have lots of different people that are going to be dealing with your specimens, and so ensuring that there is a if this then that, what's our decision, yes, no, how do we get to the right place is really important. How do we get consent if we need it? How do we get information if we need it? And then how do we build the appropriate, and this again, please don't dismiss this away. This is really, really important. How do we get appropriate documentation and reporting, particularly from an MRO, to be able to demonstrate what the MRO did in what is a very I don't want to call it a flyby, but it's a pretty limited engagement with that donor as the train's going down the track. And as I would think about it, how do I get the MRO, if they were my client, in a position to say, here's what I did, here's how I know that's what I did, and most importantly, this is how I can prove what I did.
Okay, so let's talk about this. And again, non-regulated testing. This is the only decision tree. If it's a regulated testing, the answer, there is nothing. It's to have a nice day. Okay, so let's tell exactly what I'm going to tell my MRO clients to do. So the information regarding medical marijuana cardholder status is important. It's important to you as an employer to deal with. So there are many ways that information can come across. One is they could tell your recruiter, yeah, I'm positive for marijuana, but I have a card. That's one way that needs to get to the DER. But a more common way is in the MRO interview. So I think you all know this, but an MRO has usually electronic these days, but I'm going to refer to old school paper, for a checklist more than anything else, on a marijuana positive, once they know what the drug is, they're going to ask certain questions. Do you have any condition for which you take Marinol? I mean, sort of standard questions about this particular drug. Because that would provide it, as we heard Donna Smith said, that would be, if they had a legitimate prescription, they would, for a prescribed drug, that would be negative. Just so we're clear, medical marijuana is never negative. Never negative. But what you want to hear is, and what they say is, I have a medical marijuana card. Now, the MRO has no ability to look at the card, see if it's expired, depending on how they work it. But they now have valuable information in their head because they've just been told it. So I recommend that their checklist, be it electronic or paper, have a thing, claims medical marijuana status, okay? And then the next question I recommend they ask is, do you wish me to tell your employer or prospective employer about it? Why is that? Because there's some underlying medical condition, right? And if there is, you need, arguably, it can vary, consent. Why buy trouble when you don't need it? And they need to mark that. You know, it's a box, yes, no. Do they give consent to disclose their medical marijuana status to the employer? Because the answer is they can say no, and then it's a positive, and it moves on. But more commonly, they're going to say yes. You've now documented the information and the consent contemporaneously with when you're told. And then the documentation and the reporting, I recommend, come to you as the employer, if you so wish, that it will be a positive, but they will put a comment of something that claims medical marijuana cardholder status. And this I know from DISA and DISA's MRO group, that this is exactly what they follow if the employer wants it to. So you see the idea. You've now the person, and unfortunately that's you guys, have the information to decide to apply your company policy now. So, but you have the information, the person is positive for marijuana and has a status, the MRO, because I'll tell you what you don't want. If this process doesn't work and you need to make sure your MRO does it, the reason why is because when the lawsuit comes in and you say, well, you never told me about that. And you go, yeah, but I told your agent, the MRO. Not so pleasant. It's valuable information that needs to be factored in. In some states you're going to disregard it, but I'm just saying it's information, and that's where if you have this documented in compliance, the compliance piece really serves you well to make sure your MROs are giving the information that's necessary for you back on a decision. Okay, TPAs. This is a little broader. Who has what role and what are the risks? So maybe just talk a little bit of the compliance, and we'll use an exact sort of example, David, and move forward.
So I think as I thought through, if I was a compliance officer for a TPA, my first thought would be, I may not be responsible, but I'm going to be in the lawsuit. That's just the reality of it. And so what I'm going to do is engage in risk assessment and risk management, which means I need to understand, I as a compliance officer need to understand the entire workflow that my donors are going to go through. And I need to understand where are the failure points, where are the places along the path that we can go off the rails and have a significant problem. That's risk assessment, okay? How bad is it? How likely is it to occur? So I'm going to stratify that risk. And once I've stratified that risk, I'm then going to pivot around and say, okay, who, maybe it's me and my TPA client, maybe it's somebody outside of us, maybe it's a third party, but who owns that risk? Where does that risk arise? And once I know where that risk arises, then I have to be, and I say creative a lot. I do think you have to be creative to have systems that people can connect with and not just go, oh my God, there's this compliance guy again, okay? You want to avoid that. As much as we want to avoid them saying that about lawyers, you want to completely have them avoid that saying that about compliance officers. How do I manage my risk? And the way I manage my risk as I think about a TPA is I understand all of the players in the space and how is it that I'm going to know what it is they're supposed to do and how am I going to know that they're in fact doing what I've asked them to do.
Okay, so let me use an example of this. I've been around so long, I have lots of real life examples. Let me use marijuana in Louisiana for you. This is important to know who's watching the ship on every individual topic. Louisiana has a very weird, arcane drug testing, which states they have certain cutoff levels that have to be used for all drug tests unless you are in certain job functions. Okay? And there's a number of them, but I'm going to focus on offshore, or an oil and gas company in exploration and active drilling. Okay? So we now have a situation where, and then you don't have to use the standard cutoffs. You can go lower, which is important because they're DOT cutoffs and they're kind of high. But now the question is, among all the players, TPA, MRO, collector, employer, lab, who's going to have the role of figuring out what job function this person is going to be either going to be in or is in, and so what would be the appropriate test panel. So this is an example, I think, for a TPA of, is that the TPA's job? Well, maybe if that's what the client has agreed upon, that they'll receive job things. I'm not suggesting that. Is that the employer's job? Because they're the ones that are going to know where the person's going to be working? You see, I mean, so the most important thing for, I think, particularly a TPA, because they're arranging so many services, is to have a clear understanding of, frankly, who's doing what. So a strong agreement and understanding, I call the master-servant agreement, but I'm a lawyer, but to understand what job the TPA is going to do, and frankly, what job they're not going to do, so that there's clarity. Because the worst case, and I will tell you the situation I'm talking about, is I firmly believe that everyone kind of thought everybody else was looking at that subject. No one intentionally overlooked it, just no one thought about it. You mean that there was this different role, this person happened to not be in a role that was exempt and should have had a higher cutoff. You can see how that wouldn't go so favorably, if you know what I mean. They should have been, and of course the level would have made them negative, because of course that's life. But the most important thing in a TPA, and a good example with this marijuana is understanding who's going to do what. And then auditing to that. I mean, that's part of the deal is, you know, if you're an employer, you want to understand what your TPA is doing. And by the way, and the TPA wants to understand what they're responsible for. So that's sort of a way that in real life, it can make a big difference to have that a risk assessment and who wants to do it. And other people, the employer says, look, I'm the only one who's going to know the job description, okay? I'm the only one. I can only do that. Fair? You just have to let us know that then, right? You can see the thing. So what else we got? My favorite, the employer. That's all of you. I'm going to use this because at the end of the day, I will tell you, employers get stuck with everything. Doesn't seem fair, but as you know from lawsuits, that they always sue the employer just because. And I'm going to use medical marijuana and handling marijuana positive, and I'm going to presume you're a multi-state employer. I'm going to make it difficult, and we're going to walk through. So what do you think from a compliance point of view, David?
So first of all, you own it all. So if you own it all, you own the risk. You own the risk of legal, you own the risk of safety. And think about that sort of juxtaposition for a minute. You have to own everything about this process that is regulated either at the federal level or at other levels, and you have to own the safety concern, meaning, so you're testing crane operators. You got to understand how it works how the drug testing piece works for the crane operator, and you have to understand the safety side of having crane operators in your employ. So you get the double whammy there. Faye talked about in her earlier presentation the idea of accommodation. How do we accommodate when we've got particular issues of medical marijuana? What are your policy considerations? How are you looking at, the safety and legal issues then sort of begin to meld together? I would tell you that from my perspective, much of the compliance world for a TPA and an employer are a lot the same, because there's a lot of people that are doing pieces of this process that you're not going to control as the employer. How do you know, A, who's doing what, and B, are they doing what they said? And again, if you have a TPA, do you have a good contract of who's going to do what, who's going to be responsible for what? And then that needs to trickle down to the other players in that drug testing process.
Okay, so let's talk about medical marijuana. I want to feed upon it, but the biggest thing I think in all of this space is having partners in this field that you work with and you trust, and have reputations and proven methods of delivery. And we all live with that, okay? I mean, and that's exactly right. That, as David said, you're going to be relying on a whole bunch of other people. You're going to be relying on a laboratory to test it. You're not going to test it. You're going to have agreements. You're going to have collectors that are good. So part of this is competency, verified, audited. But it comes to medical marijuana, and I covered a little bit of this, is first off, you need to find out, A, are they a medical marijuana card holder? If absent that, you can't do anything. You can't make any strategic. You have to decide whether you are going to accommodate marijuana use. That is an option. Not one I'm particularly fond of, but I'm saying in states that don't mandate accommodation. You don't have to accommodate. You don't have to drug test. Remember, this is non-regulated drug testing. I'm not recommending it, but that's part of your policy considerations for you and your executive team. Perhaps your office workers, you have a different standard than you do for a crane operator. This is a policy decision for medical marijuana that has to be developed and communicated. The next thing you have to do is know where you have employees. And I'm sorry that the laws are all different, but they are. Are you legally obligated to accommodate the prevailing theories? Yes, you are. Certain states, non-regulated. So the minimum you would have to do from a risk avoidance point of view is accommodate where it is clear that you have to, and weigh the risks of where it is a bit murky. You are going to have to, in multi-states, and this is one that is the toughest, I think most people would like one size-fits-all drug testing policy when you have employees in various states. Is there anyone who's in more than 5 states that has one drug testing policy only? You're lucky, because mostly now you're going to have to individualize it for the states in order to meet the requirements of each state. You can go to the lowest common denominator, but you might not have a very effective safety program. So I recommend that you look at it, you accommodate it to get your maximum safety benefit, but accommodate when absolutely necessary. I also, as an asterisk, I also am a big fan of reasonable suspicion, probable cause testing. Because again, you can use impairment to allow you to take safety actions as appropriate. So you're going to have to tailor it, you're going to have to make it individualized, and you're going to have to then update it and keep up with trends. This is one where your law department or your legal advisor is going to be quite involved with you. I have clients who seriously, if they have one that's problematic, they don't have that. Not very many people have medical marijuana cards. Out of all the marijuana positives, fairly few have medical marijuana cards. So remember, we're not talking about the ones that just test positive, but also have a valid card. If you want to check, it doesn't hurt to have legal counsel to check with. But because it changes. I'd like to say it doesn't, but we know what it is today. But that's where you're going to have to go in order to maximize safety and yet be compliant with state law. And I can answer other questions. I know there's other ones about people working across state lines and stuff, and we can cover that in question and answer. Okay, David, I think we got not much time. So when the bad thing happens. We'll let David tell you. Again, people don't have to like their drug testing results.
Right. So what you're going to see here is a lot of what Faye said at the end of her last presentation, and that is, from a compliance perspective, I want to know immediately, do we have a problem? Are we the cause? Are we the potential cause? Because if we're the potential cause, that's a whole different ball game for us than if we go back and look at our testing and say, nope, we're rock solid. We know that we did the right thing. Doesn't mean that we're not concerned about the claim, but I'm going to get to the answer of, do we have exposure, very quickly. And then once I get to the decision of exposure, if in fact we cause the harm, I am all about fix it. And I don't mean fix it in the context of a lawsuit. I mean fix it with the person that was harmed. Do it quickly, do it transparently, do it in a way that says, and you'll get all kinds of schools of thought about this, but in almost 30 years of doing this, I can tell you that when you are upfront with people and say, you know what, we made a mistake and we're going to make it right, that usually yields tremendous results. I'm going to engage legal immediately for, like we talked earlier. I'm going to protect my data as I'm going through my investigation. And then I'm not going to waste a good failure by not going and fixing what failed. As a compliance officer, and this will sound a little counterintuitive, sometimes the best thing that can happen is you get the bad thing, and now all of a sudden the thing you've been trying to fix for 6, 9, 12 months, all of a sudden you now have the catalyst to fix it because the bad thing has happened. And you know, I don't have to go in and do I told you so. I just walk in and say, hey, let's fix this. And everyone knows that that is not the time to say, we don't want to fix it. Because I've got the claim letter in my hand. So take the bad. I mean, I'm a big proponent of the bad is always part of the good. Take the bad and find the good out of it.
All right, from a legal perspective, when the bad thing happens, so I get the call immediately. Lawsuits cost companies an incredible amount of money, not just from the lawyers, but also from the time and effort that you're wasting. Okay? I know it's arcane. It's sort of craziness. I think they do it on purpose. My strategy, and this is many schools of thought, in drug testing in particular, the facts are well known. And because it's forensic, and by the way, incredibly documented. You have the data pack. You have the external chain of custody. You have the MRO notes. It's all documented. And by the way, in a lawsuit, they're going to get all that stuff. You can't change it. And again, we're assuming that, that it looks rock solid. I do not fight. Everything that I fight about that I'm going to lose costs my client money and time and effort. So I provide early up front all the information that they would otherwise get with a smile on my face. Because I often can explain to them that what they think happened didn't happen. They see drug testing as incredibly arcane because they don't understand it. I am a big cooperator. It's not a sign of weakness. It's a sign of being an effective lawyer. You always see people fighting and tooth and nail and, a little hubris, in the courtroom, and I'm the biggest. Judges hate it. Everybody hates it, and clients particularly hate the bills. And by the way, it's fine to fight if I get somewhere. If I'm going to lose anyway, because my rule to all the attorneys that I train over many, many years is, does it move the ball forward? And if it doesn't move the ball forward, don't do it, which means cooperate on everything that doesn't give you harm. That's how I believe. I look for early resolution or disposition. Most cases don't go to trial, my friends, but it doesn't mean I settle them. It means that there's motions, there's ways to legally educate the court and the other side of why you're right. And those opportunities. And I will confess, and I kind of fight like crazy if those don't work. But it means that you're protection, you're using this less money, and you're also trying to get out as you can. You also have a clear conscience because you've done everything you can at every moment to try to resolve the legal dispute that's going on. All right, we have some time for questions. We have no time for questions.
No, unfortunately, we're
I see the big wave at the back. That's like, hey. All right.
But in an hour and 5 minutes, we'll have networking with food and drinks, and Faye will be available, as will David. You can ask them questions. They'll have their presentation there. We'd love for you to join us for that.
Perfect, thank you.